Okay. Hey everybody, hopefully you can hear us clearly. My name is Shruti Gurudanti. I'm one of the partners at the firm and also the director of our corporate transactions group. We have our lovely corporate transactions group sitting out here, a couple of them, and a lot of them likely joining online as well. So we'll give everybody a couple of minutes to keep joining in. We have a good group of people. If you're having any struggle with hearing me clearly, please leave a comment in the chat. It should be available. This session is being recorded, so if you're not able to listen to the whole thing, you need to drop off. Don't worry about it. It should be made available to you on our website. The presentation deck is also going to be made available on the website. All right, we'll give it one more minute and then I will get started. Oh, we do have a Q&A box available in Zoom, and so feel free to drop your questions as they come to you. All right, well, we'll get started. I know people are trickling in. So again, this session is being recorded. The recording will be available on our website. If you are having any struggle accessing that, just drop me an email and we will get that over to you. All right, so we're going to be talking about the Corporate Transparency Act today and how this will affect your business. My name is Shruti Gurudanti. Again, I am one of the partners at the firm and also the director of our Corporate Transactions Group and Aerospace Division here at the Rose Law Group. All right, with that, so what exactly is the Corporate Transparency Act? Next slide, please. So this is something that came into effect, the reporting obligations came into effect January 1, 2024 this year. And essentially the reason for having the Corporate Transparency Act is because the government wants to really understand the ownership of various US entities that are not necessarily being regulated right now. And the goal is to avoid money laundering, terrorism, tax fraud, and other illegal activities. The worry is that there are a lot of shell companies as of today that are being used for money laundering activities, and the government really wants to stop these activities from taking place. And so they came up with this thing called the Corporate Transparency Act, which is the most notable addition. And essentially, Congress has directed the US Treasury Department's Financial Crimes Enforcement Network called FinCEN to establish a what they're calling a national registry of all the beneficial owners of the entities that are being reporting companies. And I'll talk about all of these things going forward. But just so you understand, it's really to avoid bad actors or to stop bad actors. And so I would hate for this to be a death by PowerPoint. If you have questions, comments, concerns, please stop me in the middle, leave questions, and I will get right to it. Okay, with that, next slide, please. So just by way of an example, the Corporate Transparency Act, I believe, is impacting over 32 million businesses as of today. And we will be, as part of this presentation, talking about who must make these filings, when must the filing be made, what information needs to be provided, and what are the penalties if you do not comply. Next slide. So who must file? What are the entities that are subject to the Corporate Transparency Act filing? So the definition is all reporting companies unless an exemption applies. So if you are a domestic company, so you're a corporation, LLC, limited partnership, or any entity, and here's the operative term, that has been created by filing a document with the government, with an authority, then you are a reporting company unless an exemption applies. So if you're a foreign company, for example, you're a foreign entity registered in Canada, and you have filed an application in Arizona to be a foreign entity registered here to practice, you would also be considered a reporting company. So if you're an entity that has filed a document in order to get created in the US, then you are considered an entity that needs to provide this reporting under the CTA. Question I get a lot, are trusts are required to file this? Not all trusts, especially the estate planning trusts, are required to file it. But again, if you are created like a statutory trust, then presumably you may have filed certain documents with the government during the time of creation, which means you are required to file the beneficial ownership report or the reporting under the Corporate Transparency Act. General partnerships, again, you don't need to file anything. Next slide, please. So exemptions, we all love exemptions, right? There's a rule, but there are always exemptions to the rule. And there are about 23 exemptions in this case where there are certain of these exempt entities that do not have to comply with the filing requirements or reporting requirements of the Corporate Transparency Act. And those are your public companies, registered broker dealers, insurance companies, banks, and the ones that I've highlighted in bold and in red, we'll talk a little bit about those. But essentially, the exempt entities, the thinking for that is these are already being regulated under other laws. So SEC or insurance companies have other regulations, and so the reporting is already being done. So they don't want to overburden and ask them to do it again. Now there are 501c3s that are exempt. So if you are a tax exempt entity like a 501c3, you are exempt from the reporting requirements. I will talk about the large operating company, inactive entity, and holding a subsidiary shortly, but these are the big or the main or the important ones, if you will. Next slide, please. So if you are a large operating company, you are exempt from the Corporate Transparency Act filing requirement. In order to qualify as a large operating company, you need to be an entity that employs more than 20 full-time employees in the US. More than 20, not 20, more than 20 full-time employees in the US. You have had to file a federal US income tax report the last year showing your gross revenue of more than $5 million. So again, gross receipts or sales. And so all three requirements must be met. And you operate from a physical office located in the United States. So again, if you have more than 20 employees full-time in the US, you have more than 5 million in revenue reported as of last year in your tax return, and you have a physical office in the US, then you qualify as a large operating company and you are exempt from the Corporate Transparency Act filing requirements. Now, it is possible that some of you are thinking, well, I have 20 employees, but I don't have 5 million in revenue. If you don't satisfy one of these, then the exemption doesn't apply to you. So, for example, today you have 23 employees, but less than 5 million, and you operate out of Scottsdale. You do file the exemption, you do file the Corporate Transparency Act filing as of this year, but next year, say you have the 5 million in revenue as well satisfied. You do have to at that point file an update to say that now you are an exempt entity. So just keep that in mind. Next slide, please. Exempt entities and the inactive entity exemption. So this is one that I would highly recommend for all our real estate folks to look at. It is very common that you will have entities that you create sometimes with the mindset that, oh, I might buy a property and store it here, or think about doing certain businesses and create entities, but really nothing is happening in them. Now would be a good time to shut these down so you don't have to worry about filing the CTA filings for this entity. But an inactive entity exemption is if this entity existed prior to January 1, 2020, it has not engaged in any active business, so it truly is inactive. It is not owned by a foreign person, directly or indirectly. does not hold any assets, in the last 12 months has not seen a change in ownership, and has not received or sent any funds. So there's really no monetary activity of more than $1,000. All of these conditions have to be satisfied in order for this entity to be considered an inactive entity, in which case then it is exempt. Now, if you have an entity that holds ownership interest in a downstream entity, right? Like sometimes you have a holdco that has ownership ownership in 3 other subsidiaries. That is not an inactive entity that is holding assets, so it doesn't satisfy this exemption. Just something to keep in mind. Next slide, please. And the third most important exemption is the subsidiary exemption. So if you are a subsidiary that is controlled or wholly owned, please keep in mind the difference. You are controlled or wholly owned, whether directly or indirectly, by certain exempt entities, then the subsidiary is also considered an exempt entity. So for example, if I have a large operating company, right, and that has a 100% subsidiary that is 100% owned by the large operating company, then that subsidiary is also considered an exempt entity. Definition of control is generally what we in corporate law consider as control of ownership or voting rights or decision making. It has to be a 100% control, not a partial control. Only then will the subsidiary exemption apply. Now, there are certain categories of subsidiaries that this exemption doesn't apply to. So for example, if you're a pooled investment company, a money services business, or an entity assisting a tax exempt entity, cannot use this subsidiary exemption. Please do not ask me what is the logic behind these 3 items. That's what they said would be not able to qualify. So there you go. Okay, so before we go on to the when or the timing, I'm going to stop real quick and see if we have any Q&A questions so far. Okay, none. All right, so everybody's clear who has to file. Great. So when must the filing be done? So this is not an annual filing. It's not something that you have to do every year. It is a one-time report that has to be filed, and the timing of the filing depends on when the entity was created, and then when there are certain changes that take place in the information with regards to an entity. So let's talk about each of these. So the due date for the initial report would depend on the date, like I said, when it was filed, but when it was created. So if the entity was created before January 1, 2024, this year, then you have all 12 months, that is until January 1 of 2025, to complete the initial filing under the Corporate Transparency Act. Okay, let that sink in again. If you have an entity that was created before January 1 of this year, you have all 12 months to complete that filing under the Corporate Transparency Act. If your entity is going to be created between January 1 of this year and December 31st of this year, then you have 90 days from the date of creation to complete this filing. So for example, if you are creating an entity today, don't stop at forming that entity. You have to make sure that within 90 days you are complying with the Corporate Transparency Act filing and completing that beneficial ownership report filing. Okay? Entities that are formed after January 1 of 2025, they need to complete the Corporate Transparency Act reporting within 30 days from the date of formation. So the thing that I would like everybody to keep in mind is it's really 30 days that the government wants us to complete this filing within. They've given us the 90-day period this year because it's a new law. They want you to get comfortable with it and things like that. But really, it's 30 days that is the time period within which the filing needs to happen. So here's where it's going to get really tricky. if there are changes in the information being disclosed on your report, you have to report that changes within 30 days. And here is where it's going to get really difficult for really complex entities, like you're a startup, you have tons of investors, or you're a hedge fund, an investment company. Here's where it's going to get really tricky in trying to make sure that your investors, your owners are giving you the requisite information so you can file these updates within 30 days. So what we've started doing as a team here at the Rose Law Group is starting to include requirements and obligations within operating agreements, bylaws, which obligates the owners, the shareholders, the members to provide changes in their information as soon as possible so that the entity can make these filings within 30 days and they stay compliant. So if this is something that is not in your governing documents right now, best time to take a look at it to make sure that you are staying on top of it. Next slide, please. Okay, so now we're getting to the what. Okay, we talked about which are the entities that need to comply, when does it have to be filed, so timing, and now what it is that we're trying to do. Next slide. Okay, so the report is, if you look at the beneficial ownership report, and I have like a copy here, you're welcome to, if you Google Corporate Transparency Act Beneficial Ownership Report, it should take you to the website. If you look at the form itself, it's fairly simple. It shouldn't take much time. But really, they want you to share information about 3 critical aspects. The company itself, so details about the company, then the details about the beneficial owners. And now, again, keep in mind, if your company is owned by a trust or another entity and then layers of other entities, the purpose of this is to get all the way upstream to an individual owner. So you have to keep in mind that they're not asking you to disclose the entities above, they're asking you to disclose the individual owners that control or own those entities. And then the third piece of information are company applicants. So company applicants are people who have helped you create the entity. So folks like lawyers, paralegals, your corporate secretary at your company that has helped create the company, those folks are considered company applicants. Now, the good news is you don't have to worry about reporting the company applicants for entities that were formed before 2024. So I can think of, like, I'm sure my parents have entities that they created 20 years ago. There's no way they're going to know who was the attorney who created it or what was their name and this, that, and the other. Presumably that person has retired. So the government is not asking you to go after that information. It only applies for entities formed after January 1, 2020. Okay, next slide, please. So just basic information about the reporting company itself, address, where it was formed. You must have a federal tax ID number that needs to get reported for the company. Next slide, please. Okay, so information that they need for each beneficial owner and your company applicant. So like I said again, and at the risk of repeating this, the government is really looking for information about the individual owner. You need to pierce through the corporate veil all the way to the top to show the individuals who actually control the entity or own the entity. And they're looking for information like the name, date of birth, address, this is your residential address for owners and company for the company applicants. And then they're looking for a photo of your of some sort of ID document. Now, I know that a lot of people are going to likely freak out that why does the government want to have this kind of information? My passport is sensitive information. But something to keep in mind is that this is not information that is publicly available. So I won't be able to do like a search and pull up this information. This is, and we'll talk a little bit about where this is being kept and who can access it. But it's really for the federal government, state, or law enforcement to pull up this information if at all there is a need to look at any bad actions that are taking place. So really, it's not a publicly available database for people to search and look into. I would recommend, especially for folks who have multiple entities, to consider what's called creating a FinCEN identifier. So, of course, Congress recognizes that there are folks like me. I'm going to likely be doing this for a ton of our clients, so I already went ahead and created this FinCEN identifier, which is essentially like a social security number for me as a company applicant. Now, once I have that FinCEN identifier, I don't need to show my passport and driver's license every time I try to create this filing for an entity. I can just use that FinCEN ID, which acts, like I said, like a social security number, which helps to form or file these applications. So that also, just from a practical perspective, I have this in front of me here. It took me maybe 15 minutes to get everything done, and it's fairly simple. So folks who have a lot of entities, I would recommend that you create that FinCEN ID, so you don't have to worry about providing your sensitive information every time you file this for an entity. Next slide, please. So now we're really getting into the meat of who is a beneficial owner. And now before we get into this piece, which is a little more complex, we're going to stop and see if there are any Q&A questions. None so far. Perfect. Again, feel free to drop questions here as we move along. So who is a beneficial owner? So a beneficial owner of a reporting company is any individual, again, any individual who directly or indirectly, again, keep in mind, directly or indirectly, that means it's going all the way to the top of the food chain, if you will, piercing all the way to the top. So an individual who directly or indirectly exercises substantial control over the company or owns or controls 25% of the company, okay? So again, it is substantial control or ownership of 25% or more. Next slide, please. So here's all the fun part and why the lawyers get paid the big bucks. What is substantial control and how is that defined? Next slide, please. So an individual exercises substantial control if they have any of these characteristics that are laid out on this slide. So if they're a senior officer, like a CEO, CFO, president, manager of an LLC, these are individuals who exercise substantial control as an example, and would be people who need to be disclosed in your filings. They have the authority to appoint or remove a senior officer. So think of it like your board members of a company. Those would be considered folks with substantial control. Anyone who has decision-making authority over the company. So anyone who can say the company needs to be dissolved now, needs to reorganize, needs to sell, that individual is somebody who exercises control. And the interesting piece is they have a catch-all at the end which says, any other form of substantial control over the reporting company, which means if you have folks who have contracts with the company saying that they're a third-party manager, or someone has an agreement with the company that says that they have so-and-so voting rights and things like that, all of that would qualify as somebody exercising substantial control. So again, I go back to entities that have investors, startups, you have convertible notes and things like that. Just be very mindful that that's where it gets tricky. You have to see whether the person who holds that contract with you has substantial control. Next slide, please. Okay, just more about individuals who might have substantial control over the company, but may not have ownership interests. So a third-party management company would be a great example. They have control, decision-making control over the company, but they don't have ownership interest in the company. That is an organization, or you need to disclose information about their owners as well. Next slide, please. How is ownership interest defined and calculated? So this is slightly easier. Next slide, please. This is slightly easier when you think of how to understand ownership interest. If you have somebody who owns over 25% of stock, equity, profits interest, all of that would qualify as them having, as them being a beneficial owner. Now, what I would suggest is that if you have, multiple layers of ownership, or like, I know a lot of our clients are real estate syndication folks, and they have, different layers of ownership. Now would be a great time to start figuring out who owns what, how much of it. Having 25% of a simple, just within a class is not going to qualify. It has to be 25% of the entire ownership of the company. And again, it's not just stock, equity, or ownership interest, but if they have a convertible note, a call, put, option, they have some sort of a contractual relationship with you, which shows that they have 25% control or ownership, that would trigger the filing requirements. So it gets a little complex here. This is not, if you were to just pick up the phone and ask me a question, I might have to think about how this applies to you. And this is across the board with all law firms and lawyers right now, that we're trying to wrap our head around how all of this works. So this is something that is evolving, and there are notes that are coming out from the government every day as well on how they're interpreting this stuff. Next slide, please. Oh, there's a question, so we'll stop for Q&A. LLCs must report. Do S corps also need to report? I assume yes. So your question seems to think about, do S corps need to report? It'll depend on, again, unless an exemption applies. Yes, they will have to report. So I go back to, can you check the 23 exemptions? And the big ones being, are you a large operating company? If yes, then even if you're an S corp, you don't have to submit. If you are an inactive entity, even if you're an S corp, you don't have to submit. And if you're a subsidiary, qualifying for a subsidiary exemption, even if you're an S corp, you don't have to submit. But unless an exemption like that applies to you very categorically, you do have to complete the filing. And I would just say, if you are in that space of doubt whether to or not to, I would say please go ahead and submit it, because we'll look at the penalties in a little bit, and they're not joking here. It includes some jail time as well. So please be cautious and err on the side of over-reporting. Good question. Okay, going back to ownership or control, maybe direct or indirect. Again, I get a lot of people asking me that are trustees considered, folks exercising control, and the answer is yes. If you are a trustee, that person is going to be considered a beneficial owner to be reported on the filings. And these are just some examples of how they are looking at direct, indirect ownership. Next slide, please. Okay, so when exactly is the ownership information calculated? So for example, in order for us to consider that 30-day timeline, this is just an example of when in time to calculate that 25%. Is it the date that, as of today, or at the date when it vests, and what have you? Again, I would hate to go into this level of complexity at this time. But it is something that you need to be thinking about, so that you know exactly when your 30-day timeline starts ticking. And so if you have folks right now on your cap table that have options, or they have ownership interest, springing ownership interest and things like that, please reach out to your favorite counsel or your counsel of your choice to start figuring out how ownership interest is going to be calculated. But essentially it is, in terms of options, it's at the time that it is exercised, and in terms of direct ownership, it's as of today. So if I have 25% as of today. Okay, next slide, please. Are there any exemptions to the definition of beneficial owners? Please. Yes, there absolutely are, just like with anything in law. We have minor children. That is an important one for folks to look into. So if you have minor children who are, for example, beneficiaries of a trust, then you don't have to report about them, but you would have to report information about the parents with regards to that minor child. Employee of a company that is acting solely as an employee and whose substantial control over our economic benefits from that entity are solely because of their employment, then they are not a beneficial owner. But if there's their CEO, CFO, manager, then they absolutely are, and that exemption doesn't apply. So again, please be very careful in how they're differentiating between employee versus a C-suite or management level employee of the company. Then any creditor of a company, a domestic or reporting company, is not also going to be considered beneficial owner. Next slide. Who is a company applicant? So folks, anyone on the call who is here helping, entities file their corporate, sort of paperwork and annual reports and things like that, you may be considered as a company applicant if you're directly essentially filing the reports for the company, and then primarily responsible for controlling the filing. So attorneys, paralegals, corporate secretaries, these would all be individuals who are company applicants. But again, I go back to, this is only for entities that are created after January 1, 2024. So if your entity was formed before January 1 of this year, you don't have to worry about disclosing the company applicant information. Okay. So remember we talked about, okay, once I file this, am I like good to go, done, budgeted up? Next slide, please. That is not the case. You absolutely have to keep filing amendments and updates to your report within 30 days of the date of any change or update. Again, please remember, it must be filed within 30 days after the change occurred. And we can go into the details of, is it 30 days after the change occurs, or like how is that defined? It's essentially when the company becomes aware that a change has happened. You have 30 days from that date of awareness to complete this update. And so what would be considered as updates? So say, for example, I have an entity, I changed my residential address. That needs to be reported as an update to the Corporate Transparency Act filings. So those changes would be considered an update. Suddenly, I go from being a large operating company, which is an exempt entity, right? I go from that to becoming, I have 16 employees. Now my exemption has gone because I don't have 20 employees. Then I have to file an update saying that, hey, I'm no longer exempt, and here's all the thing. If there's an ownership change, of course, that's the obvious one. And then lastly, if there is a change in the document. So for example, if I go from being a permanent resident, I have a green card, now I become a citizen, that is information that I must disclose to the entity that I have control of ownership in, and they must report that update within 30 days. So I know, again, it's kind of hairy, but this is where companies are going to be required to be very careful. Include language in your operating agreement, in your bylaws. If you don't have that already, we're already doing that for a lot of our clients. Penalties, and it seems like we have one question in the Q&A, so we'll stop real quick. Oh, okay. All right. Any other questions, comments, please feel free to leave it in the Q&A section. But we are looking at penalties now. So what happens if you just forget about doing this because it's a new thing, you've never heard of it, all of that stuff. Don't take this stuff lightly. The penalties are pretty severe. It's $500 a day for failing to report, and you can be subject to 2 years of jail time. Failing to comply, of course, could mean that sometimes you forget and you didn't voluntarily do it, but malice or things like that. There is a safe harbor for that, but I would recommend that let's not get involved in trying to prove to the government that you didn't have fraudulent intent, because that is an uphill battle. So let's go ahead and file these things as soon as possible, because they're not joking about getting this information. Okay, question, love it. Is a non-exempt LLC that has no manager but several members, who is responsible to file the report? Any of the member can file the report, or if you have your lawyer who generally helps you with, your day-to-day corporate work, that person can help you. If you have a paralegal, they can help you. There are also third-party registered agent companies. Like if you're a Delaware company, I know CT Corp is one that's fairly common. They can file the requirement also for you, but you have tons of options. Good question. Okay, so I hope everyone's clear. They're not messing around. $500 a day fine, and it can go all the way to 2 years of jail time if they can prove that you willfully provided false information or you fraudulently reported something incorrectly. So again, be careful with that. Looks like we have another question. Okay, great. You're very welcome, Michael. So who can access the information once the report is filed? I get this question a lot, that, what is the purpose of it? Who's looking into my stuff? Who's spying on me? And the answer is, really, this is not accessible to the public. I go back again, like I said previously, this is not information that I can easily pull from a public database. It's not subject to the Freedom of Information Act, so no one can willy-nilly just file and, try to collect it. But there are certain government agencies that will have access to this information. So law enforcement, the Treasury Department, tribal governments, and financial institutions when they do their KYC and diligence work. But essentially, again, going back to why this whole thing came into existence, the government really wants to clamp down on money laundering and illicit activities. And now there's I'm sure a lot of people will say that, really it's a whole lot of work to probably catch a handful of people, and that might be the case. But this is how they think they're going to accomplish this. And really the information is only going to be available to law enforcement when they think that an entity is conducting illicit activities without disclosing their true owners. It will be stored on a government, sorry, just to go back, the information will be stored on a government sort of safety database. So again, they will have all the bells and whistles, but sure, but just like any data, it is going to be open to being attacked. That's just something that we have to understand. Next slide, please. So what can you do now that we understand what it is, who must file, when must you file, and what information must be filed? What are the next steps that you can take right now? What can you do? You can start looking up the PDF version or the online version of the report itself, which is called the Beneficial Ownership Information Report, or the BOI report. It's a fairly simple form. If you look at the form, it'll seem fairly easy to do. Shouldn't take you very much time, but that truly depends on the level of complexity involved in your entity. If you have even the tiniest bit of question about who would be a beneficial owner, who would qualify as having substantial control, who would be the company applicant, please reach out to a lawyer that you are comfortable working with, and they can help you identify that. If your entity has even, like layers of ownership, you have contracts and things like that, again, I would highly recommend that you speak to somebody to make sure that you are complying appropriately. And then lastly, if you have not done this already, please include language within your operating agreements, bylaws, etc., to require your owners to provide information changes to you as the company, so you can stay compliant and report the consent within 30 days. So just like, and of course I have to say this to everybody, I am not giving you any legal advice here. This is purely for informational purposes. And so please do consult with your specific lawyer about your specific circumstances to determine what, if any, obligations you have under the Corporate Transparency Act and what do you need to do to stay compliant. But with that, hopefully this was helpful in figuring out where you stand from a compliance perspective. Next slide, please. All right, that's my show, everybody. Questions, comments, concerns?
Do you guys have any questions?
Yeah.
That's how really sexy works.
Oh my God. No questions. All right, we'll give it maybe, oh good, we're on time. We'll give it 1 more minute. If anybody has questions, comments, concerns, please feel free to put it in the Q&A here. Madeline, if you don't mind leaving my email, please, in the chat or somewhere so folks can reach out, that would be great too. Again, I am here, an attorney at the Rose Law Group. If you have questions about any of these things, please feel free to reach out to me after the fact and we can chat. Again, I have to say, none of what I talked about right now was legal advice. Please have, oh, there you go. We have one question. Please speak to an attorney in order to specifically have your questions responded.
Okay, Alvena, we're here to hear your question. Seems your mic is just, there you go.
Yes, I'm sorry, thank you. Could you share your presentation with us?
Absolutely. We'll go ahead. We have our guys' email for registration. We can send them out to you. We'll post it on YouTube and it'll also be in our newsletter. If you haven't signed up for the Deal Maker already, you can go ahead and add your emails to that as well.
Okay, thank you.
Okay. All right. Well, thank you, everybody. Have a wonderful time here in Arizona. Enjoy the rain that we are experiencing here in Scottsdale, Phoenix. All right, guys. Thank you. Bye-bye.